Good afternoon and welcome to the second of our residential property forums for lawyers in Northern Ireland. My name's Robert Kelly from Stewart Title, and we're once again joined by Ian Quayle, who'll be leading the conversation today. Thank you all for attending the second one. We had a good turnout for the first one, some interesting questions at the end, which Ian didn't have time to deal with. So I think you'll be kicking off with those today, Ian, will you?
Yeah, we'll have a look at those. Yeah, we'll have a look at loads of different things as well, if that's all right, Robert.
Yeah, that's fine. The important thing is obviously for people to take part. It is a forum. It's not just for Ian to talk. So any points you want to raise in the chat feature, please do so. Very keen to have contributions from you all. Really want to know the issues that are bugging you at the moment, and hopefully Ian can give you some tips on how to make them slightly less irritable. So Ian, over to you.
Thanks very much. Thank you, Robert, and good afternoon, everyone. Thank you very much for coming along today. This event is sponsored by Stewart Title. Robert Kelly from Stewart Title, Stephen Smith are listening in the background, and we also have Liz, who is the sort of manager for the Northern Irish business. So if you have any questions or queries about any defective title matters, then do contact Stewart Title. I'll give you some further contact details before we finish today. As far as this event is concerned, if anyone has any sort of burning topics or issues, then feel free to sort of include them in today's forum. We're happy to talk about anything and everything. As Robert said, we had some sort of issues from last time that we can talk about today. I've got some new issues as well to talk about, and I'm delighted that I've got John Logan with us from Stewart Title, Robert Kelly with us from Stewart Title, both of whom are able to deal with any questions or queries that you may have concerning title. So let's just have a look at some of the things I want to talk about today. First of all, I want to talk to you about dealing with inquiries before contract, because there have been some recent interesting cases on this topic that I want to sort of share. Good afternoon, Liz. Nice to see you. Some interesting questions and issues arising with regard to inquiries before contract. The first one is how do we advise, or what do we advise sellers with regard to replies to inquiries before contract? And I think it's important, firstly, to highlight to the client the importance of getting things right. Secondly, the potential dangers of getting things wrong. And thirdly, making sure that clients are aware of their ongoing duties with regards to inquiries before contract. There's a case just recently called Rossa against Pacifico, which I think I mentioned the first time we were together. And in this case, you had a seller being sued for misrepresentation on the basis that an estate agent had provided to the buyer a copy of a specification and drawings that had been obtained or undertaken by the seller during renovation works, in which a flat that was a one-bedroom flat had been converted into a two-bedroom flat. And the court said that the information that had been disclosed by the estate agent to the buyer constituted a misrepresentation on the part of the seller, because the documentation revealed this was a two-bedroom flat, when in fact, as it later transpired, due to building regs and planning issues, it in fact could only ever be a one-bedroom flat. So first point, even though this wasn't information directly from the seller to the buyer, but was via a third party, the seller's estate agent, the seller was held to be bound by what constituted a misrepresentation. Secondly, in the inquiries themselves, the seller was asked about if it was aware of any breaches of planning permission and building regulations. In fact, what had happened is during the conversion work, a Velux window had been put into a room to convert that room into a bedroom. Planning permission had not been obtained, and building regulation consent and approval had not been obtained for a Velux window, a skylight, in the roof of the building. And the enforcement officer from building control for the local authority attended and required of the buyer that the Velux window be removed and the roof reinstated. The buyer sues the seller on the basis that you told me you were not aware of any breaches of planning permission or building regulations. And the fascinating thing about this is the judge said, if you are selling a property and you're asked the question about are you aware of any breaches of planning permission or building regulations or anything else, then you can't just give a blanket I'm not aware of it, you are put on notice that you should make reasonable inquiries to ascertain the position before providing a response. Now, that decision, that second limb of the decision, is an extension of a case that was called William Sindel PLC that you probably heard about and read in all the textbooks. This is where the seller gave the not so far as the seller is aware type of response. And the court said, if you say that, it's implicit that you've undertaken reasonable investigations in order to be able to firm your view or firm your opinion up in connection with the response. So that case and another case involving Japanese knotweed in England both highlight the dangers of simply guessing or not undertaking reasonable inquiries when you're a seller in providing a response to inquiries before contract. The other point with regard to inquiries before contract, make sure that your client is aware of their ongoing duty to update any information in the replies to inquiries. And if you're acting for a buyer, I always say to buyer clients, use the inquiries as a checklist to satisfy yourself as the state and condition of the property. Also, make sure that you understand and appreciate that although it is possible to pursue a claim for misrepresentation against the seller in the circumstance that I've just explored, for example, you may not in fact have the appetite to do so due to the cost that could be involved, due to the risk that could be involved, and due to the time that's likely to have to be spent in that connection. So be careful. Inquiries before contract are part of the conveyancing process. There are lessons to be learned from recent cases. The seller shouldn't be simply guessing a response. The problem with the two cases that I've seen is that it's now probably less safe for the seller to try and be helpful. And it's probably safer from the seller's perspective when they're asked a question just to say, look, I don't know. So in the Japanese knotweed case, what you had was a seller who was asked if there was any evidence of Japanese knotweed in the garden of the property he was selling, and he said no, he wasn't, when in fact there was Japanese knotweed in existence. Now the seller maintained he didn't know. The court, I think, was a bit dubious about that sort of bland statement, but nonetheless, the seller was held liable for the cost of eradicating Japanese knotweed from the garden. The cost to the seller considerable with regard to the damages due to the claimant, buyer, and also liable for not only the seller's legal costs, but the buyer's legal costs as well. So be careful with inquiries before contract. In your retainer, when you're scoping the retainer with regard to the seller, make sure the seller understands the potential vulnerability. Make sure the seller understands your role, because you are required to check the information in the inquiries before contract against the information that you hold on file. But the likelihood is that you're not going to have sufficient information to be able to challenge the seller with regard to whatever they're saying in the inquiries. So I don't know if you've seen those cases, I don't know if you've heard of them, but Rosser and Pacifico is one. If you want a copy, I did a sort of case report on that. If you want a copy of that sort of note about the decision of the court, drop me a line and I'll send it to you quite happily. Second point I want to talk about is something's just arisen over the weekend. Again, problems with boundaries and boundary identification. And yes, we've got registers. Yes, we've got plans, etc., that are produced as part of the conveyancing process. But to what extent can we safely rely upon them? And to what extent are our clients boundary sensitive? I think it's always important when we're acting on behalf of a client in a residential or indeed a commercial transaction that we assess whether there's any boundary sensitivity. By that I mean, do we have any situations where we need to know where precisely a legal boundary sits between us and an adjoining property? Is there a private access and we need to know that our land bounds that access? Do we know that there's been a history of boundary dispute in the past, and therefore it's necessary to try and clarify whether there could be such a dispute in the future? All of these sorts of things, I think, need to be identified at the start of the transaction, and then we need to be aware of two things, I think. One, making sure that we set realistic client expectation. that normally in the conveyancing process, the identification of a legal boundary is going to be difficult, if not impossible, particularly where we've got a boundary shown on a plan. The scale of that plan could be critical, but a red line on a plan or a black line on a plan could in fact be 1 metre, 1.5 metres in width. And the actual legal boundary is a pencil line that separates my title from your title. So 2 or 3 things with regard to boundaries. 1, check agent's particulars. Make sure your client has seen the particulars. Check the description of the property in the contract and check the title and have a look at the description of the property in the title. As far as the reliance on plans is concerned, I can show you loads of cases where the courts have been really critical of lawyers and clients relying on plans. And in essence, we need to be careful that we've got accurate measurement or accurate description or physical features that enable us to clearly identify the legal extent of a title. If we don't have that, then I think the safest thing to do is to warn the client about the potential problem that we're facing and that they're facing. Other things that I think are possible, if we have had a situation where a boundary is altered or where we're not clear where a boundary is, we could put a special condition in the contract asking the seller to verify the location of boundary, etc. We could do that if need be. I'm just going to put this in the chat if I can. What would people do? Greg, Megan, Ronan, if I was a client of yours and I'm aware on my inspection of the property that, or aware from the replies to inquiries before contract, that there's been a boundary dispute, what would you do? Terry, again, very interested in how you deal with this from a practical perspective. So there's been a dispute in the past. We're acting for the buyer buying the property. The buyer's aware of the problem. What could we do? Is our stance, we're just going to warn the client there's not much we can do, and that caution needs to be exercised with regard to the client on the basis that we could be walking into a boundary dispute? Or are there other steps or measures that can be taken? My view is that you set realistic client expectation from the outset. You can instruct a chartered land surveyor to produce plans for you. You could enter into a formal boundary agreement with a neighbour, but I'm just interested as to how people would react to that situation. Anyone? While I'm waiting for that, if you're selling a plot and you're staking out a plot or pegging out a plot, do make sure that you indicate where on the peg or the stake the boundary actually sits. Is it the centre point, or is it the western face or the eastern face of the stake? Because, you know, those couple of centimetres could be sufficient to generate a dispute. So anyone got any views on that? While I'm doing that, John and Liz and Robert, Stewart title and products in connection with boundaries, what have we got? Anyone?
Well,
hi John.
Basically we've got adverse possession type products.
Yeah.
So that would be the main sort of one that we would have, but we've also got products where you have actually gone down the route and managed to get the title, the defective part of the title registered, albeit that there's some sort of qualification to that title. So we look at that as well. So it would either be one or other. It would be an adverse possession issue, or it would be a restriction on the quality of the title. The other thing that I'd say there is that if the defective area that you're occupying is already registered, particularly to the next door neighbour, that can give us some difficulties. It's not impossible, but that's one of our sort of issues that we have at the moment.
Yeah, I've got you. Thanks for that, John. Yeah, I mean, one of the issues with a defective title policy, as John was suggesting there, is this idea about awareness of the problem and awareness of the existence of a policy. You've got to be very careful about disclosure issues. Again, you know, if you are investigating title, then my view, and Robert, if you could come in on this, my view always is that if you're undertaking the searches that a purchaser would undertake in a standard conveyancing transaction, there's probably nothing there that would worry you as far as disclosure is concerned. But the moment you start talking to former solicitors or neighbours about the problem or the issue or who owned what or what's happened with regard to boundaries, that could cause a problem, Robert. Or John, if either of you could join me, that would be great.
Well, as far as I'm concerned, once you start discussing these issues with neighbours, a lot of the time it means that we can't really take the matter further. So it's a matter of keeping quiet about it, because as soon as there starts to be a discussion with neighbours, even a general discussion can lead to, you know, something that would restrict us from issuing a policy. So
absolutely, my
advice would be, if you're going down the policy route, you cannot discuss this with anybody else.
Yeah, I'm the same. Yeah, you either go down the policy route. If you're going to investigate the problem or do anything else, you're probably rendering the idea of an insurance policy for the risk or for the issue becoming impossible, because the insurer quite rightly will not insure where there's any sort of suggestion of disclosure. The other thing that I think is important relating to boundaries, as I mentioned earlier, just making sure that you're telling the client about the problems associated with boundary identification. Greg, I know you're typing something at the moment. I'm just going to wait for you and allow you to do that, and then we'll have a look at that issue. Formal boundary agreements are quite useful. There was a case in England where a High Court judge said a formal boundary agreement is binding on the parties that enter into the agreement, but not binding on subsequent landowners, which is interesting and got everyone quite excited. So again, I'm still waiting for you, Greg. We'll just wait for that and see what comes up. Other issues that I'd like to talk about. I'm very interested in what you're doing with case management systems, what you're doing with electronic reporting on title, etc. I've had a few sort of companies talk to me about product that they've got that is potentially available in Northern Ireland. And I was just wondering, anyone that's attending today, have you got a case management system for conveyancing that you're using? Are you looking at buying such a product? Interested in what the sort of general consensus is with regard to case management systems. And reporting on title and electronic reporting on title, what are people doing? Greg, I don't know whether you're wanting to join and speak or whether you're typing something, but I keep seeing that you are attempting to do something, so we'll just give you a minute or two and see what that is. If anyone has any topics that they want to discuss on the next occasion, I'll just put my email address in the screen here for you. But the interesting thing with regard to case management systems is this idea of integration. Right, okay, thanks, Greg. I'll come back to this point in a moment, Greg. Thanks for that. On the issue of case management systems, making sure that they integrate with other systems is so important. Is anyone using any form of electronic reporting on title where data is migrated from search companies and others and automatically populates a report on title? Interested to hear what people have got to say for that. Right, I'm going to look at what Greg's saying. Hi, Greg. Encountered the issue, John, about strip of land being merged to the next door. Made my client aware of the issue out for the purchaser and invited to obtain a boundary agreement as title is not possible. Neighbour not yet on notice of the issue. Yeah. But obviously may now be made aware of being approached about a boundary agreement. Yeah, the point that John made, Greg, and the point that you're making there, I think is so important. If you've got any form of issue associated with title, where you think an indemnity policy is going to be the way forward, then what I would do is close the doors, make sure that your client is aware of what you're doing, make sure that your client is aware of the potential dangers in talking to anyone, and then applying for a policy. The moment you undertake any form of investigative work for all the right reasons, you know, is there really a problem? can I provide information to the insurer that might mean the policy premium is reduced? So there's good intentions in doing investigative work, but my view is don't. If we're going to go for a policy, go for a policy. If we go for a policy and there's an issue, then we take a view. But I think one of the things that Robert always mentions is the fact that we should always be aware that as far as title indemnity insurance is concerned, it is a solution. It's not the solution. So there may be other ways around or resolving the issue. A formal boundary agreement between neighbours might well be the solution. Be careful about making sure you've got a properly prepared, professionally prepared plan. And secondly, make sure that in the agreement itself, you are defining the land concerned to make sure that we're not reliant on the plan, but we've got terminology that gives us an adequate description. The other thing that I think is important to do is where we're relying on measurement to have some form of concrete fixing where measurements are taken from that's sort of permanent. Now, I think it's Germany that they do this. They have a sort of concrete post somewhere on plot, and then they measure out from that so that you've always got a base figure or a base point from which measurements are taken. If not, if you've just got simply a reference to measurement, then the issue is, well, where does the measurement start and end? So we may well have a measurement that describes the extent of the plot, but not the location of the plot. Has anyone did anything with national grid coordinates in that regard? Using national grid coordinates to give an accurate fixes to boundaries. The other thing that's interesting with regard to boundaries, do be aware that there are common law principles that apply with regard to boundaries. I'm sure you're all familiar with them, but those common law principles are rebuttable. So there's a common law principle with regard to a hedge and a ditch, and where the boundary is in connection with both. But you've got to, for that principle to apply, you've got to have evidence that the hedge and the ditch, can't say it, the hedge and the ditch were planted or excavated at the same time. The moment there's evidence that the hedge was planted at a date well before or well after the ditch was excavated, the presumption doesn't apply. Got a matter on the go at the moment that's quite interesting with regard to highways. And again, important, everyone may think that the highway is sort of a metal road. It doesn't have to be. Grass verges can be the highway too, as long as members of the public have the right to pass and repass along an area of ground, then that can constitute highway. There are common law principles that where there are hedges which were planted at the point that the highway was constructed, then the boundary is the area of land between the two hedges. And of course, remember that with regard to highway, your client will own to the centre ground of the highway. The highway itself vests in the highway authority, but the land beneath it is retained by the existing landowner. Thanks for that, Greg. Anyone else got any problems with regard to disputes concerning strips of land? Ransom strips are an issue, and I tell you what I've seen people do. I've seen people ask the council to compulsory purchase a ransom strip to facilitate development. And again, with regard to ransom strips, do be careful about the potential for adverse possession. So you create a ransom strip, forget about it. The person who is ransomed, the person who is landlocked, then takes over the use of that land and brings a claim for adverse possession, thus circumventing the whole purpose sitting behind the ransom strip. Anyone got any issues with regard to sort of ransom strips? Any issues with regard to overage? Anyone dealing with any overage problems at the moment or encountering them? So going back to case management systems, I'm really interested to see what systems people are using. I'm really interested to see if anyone's using an electronic report on title. So again, Greg, can I ask you, do you use any form of electronic reporting on title? Again, massive in England at the moment. Lots of companies, lots of search companies producing systems that enable data to be migrated from searches and registers into the report on title. And again, the idea here is we're saving time. We're producing templates that the firms can use. I just did some work recently with a firm and it had 4 different officers, and each firm had their own form of report on title. And then when I did a deep dive looking at what they were doing as part of some consultancy work, every fee earner in every office had a different form of report on title. Yeah. So Greg, no one approached you to say, hey, look, we've got this all singing, all dancing product. Come and have a look at it or use it. I'm not sure. Well, let's put it this way. The idea of using artificial intelligence to produce reports on title is an anathema to me. I don't like it at all. But having a tool that enables some data to be migrated into my document so that I can then work on it, I think is quite a useful thing. So I have seen some that will actually produce the report for you. That scares me. The idea of having a template that I use for a report on title, and I've got data that's input that's automatically migrated into it, and then I can look at it and check it, is quite useful. One system I've seen, it actually shows you the register, or it shows you the lease where data is being extracted, and then shows you the report, so you can cross-check what you've got. Kirsty, you're typing something. So Greg, could you be persuaded to use that? Anybody else be persuaded to have a look at it? Some people are saying it can reduce the amount of time to produce a report on title by up to 2 hours. Yeah, Kirsty, you've seen the InfoTrack one. What did you think, Kirsty? And could you use the InfoTrack model in Northern Ireland? And the thing is, Kirsty, isn't it? It doesn't replace you. It's no way in a million years it replaces you. It just is useful. I was talking to a very experienced solicitor, and he said, it's not, I haven't got this for the team, I've got it for everyone, because even an old stager such as me needs to have something just to cross-check. And often, the more experienced you are, the more accustomed you are, and the bigger the risk that you miss something or forget something. So his attitude was, it's not just for my junior members of the team, it's for everyone. And it's for me, I'm finding it useful because it's a useful sort of cross-checking reference tool. Yeah, it is. Does every firm have a standard form of report on title that they use? Or does some firms still allow fee earners a degree of leeway? Certainly your professional indemnity insurers won't like the idea of sort of non-standard processes and procedures. The other thing that's important is to make sure that if you have procedures and policies as a firm, to make sure that those policies and procedures are put into practice. Dealing with a matter at the moment where this firm has the most marvellous policies and procedures for everything, risk assessments with regard to transactions, all manner of different things. But then when you actually have a deep dive and start looking at files, no one is using those systems and processes. In fact, it seems to me that some people aren't even aware of their existence. Be careful. So yes, Kirsty, the question I'm asking then is, could you use the InfoTrack system in Northern Ireland? Would you be a sort of an advocate for its use in connection with your work in Northern Ireland, Kirsty? Well, I'm waiting for Kirsty. Thanks, Kirsty. She's typing again for me. That's great. Anyone got any burning issues, any problems with regard to files, etc. at the moment that's causing a nightmare or nightmares? So I'm just waiting to see what Kirsty says. So InfoTrack have a system. Most of the search companies do. And I'm going to get a search company to come along to a future event to talk about that. So I'm just waiting for Kirsty, and then we'll push on. The next thing I want to talk about is the Building Safety Act. I'm spending my life doing a lot of work in connection with the Building Safety Act, and it is a nightmare. And what I want you to be aware of is that it does apply to Northern Ireland. Has anyone had a look at it? Has anyone had any training on the Building Safety Act? Would anyone like to know how it impacts on residential leasehold work in Northern Ireland? Because it does. It's not quite the same as in England, but it is a problem. All right, Kirsty. Yeah, I think as well, Kirsty. It surprises me that a lot of the companies that have this product haven't looked at Scotland and Northern Ireland, in that the benefits in England will be just the same as in Northern Ireland and the UK. Yeah, it is, and it is in Scotland, Kirsty. I agree. It is more bespoke and harder to implement. But the point here is that what you've got with some systems is libraries of terminology that you utilize in your report. So the fact that it is more bespoke, the fact that it is less standardized, I don't think is necessarily fatal to the concept. But just so everyone's clear, I'm not suggesting that the use of artificial intelligence, the use of electronic reporting on title replaces our role. I think it supplements it and gives us more time to make sure that we're looking at some of the tricky issues, and also gives us more time to ensure that we're transmitting information to our clients, so the clients are getting to know what are the issues and what are the problems. Because again, that's a massive thing. We mentioned this last time with regard to negligence claims. The inability of firms to transmit information to clients such that clients understand and appreciate the points that are being made. And Kirsty, I don't know about you, but I see some reports on title that are huge, 80, 90 pages in length. And again, I think I'm partly to blame for this. I'm telling people, look, you've got to warn clients about this, you've got to warn clients about that. And therefore, what happens is we generate more and more information in the report on title, so the key messages get lost. How I deal with that is to suggest to practitioners that they use interim reports. So you're producing a report at each stage of the conveyancing process for clients. And secondly, that you use supporting information sheets, etc., for clients. So at the start of the transaction, you could give, and I saw a firm in Northern Ireland doing this recently, they provide an information document for the client showing the conveyancing process from start to finish, showing the key features, the key documents, and explaining the process, and then tying in the report on title to that. And I think that's a useful thing to do. I think the other thing that's useful is to make sure that your retainer and the report on title are consistent with one another. And I also think it's important that as far as the retainer is concerned, we keep the retainer under review. We talked about that last time. In the retainer, we might be telling clients that there are certain things that we're not doing during the life of the transaction, but then it transpires as the transaction progresses that there are things that need to be done, which might have been out with the retainer to start with. We therefore have to revise the retainer and expand it and make sure the client understands and appreciates what's being done. So going back to the Building Safety Act, residential flats and apartments, anyone looked at the Building Safety Act and how it would apply? There are issues with such as the golden thread, the production of documentation by landlords or by accountable persons as defined under the Act, persons that are entities that are responsible for the repair and maintenance of common parts, and the need to keep documentation relating to construction, relating to building regulation, and then relating to building safety management. It's a vast, vast issue. At the moment in England, everyone's tied up or concerned about Schedule 8 of the Act and building safety certificates and landlord certificates. And that's important for transactional property lawyers. What's even more important, in my view, is this issue about management, building safety management, and the responsibility of landlords, the responsibility of accountable persons and leaseholders with regard to building safety management. Building safety management, not just fire safety, but also safety relating to the risk collapse of buildings, etc. So again, I'm surprised that no one has raised that as an issue or seen any guidance relating to it. I've trawled the web, and all I've found on the Building Safety Act for Northern Ireland is a lot of sort of construction lawyers and a lot of surveyors and architects discussing issues and highlighting issues, but I haven't seen any sort of conveyancers sort of addressing it. I'm just interested to see what people are doing. We're currently looking at the Building Safety Act insofar as it relates to Wales, position again slightly different to England. Then we're going to move on to Scotland and Northern Ireland. Scotland and Northern Ireland, it's less transactional stuff, more building management stuff from what we can gather. Okay, other things, other issues. What else is sort of burning a hole in your sort of files? What's causing issues? What about delays in the conveyancing process? Are we seeing faster transactions? Are we seeing slower transactions? If there are slower transactions, what's causing the problem? And what can we do about it? I was looking this morning at something with regard to property certificates and the DOE certificates taking sort of 3 weeks to be obtained. Is that still the norm, or where are we with regard to DOE certificates at the moment? Anyone let me know? And again, statutory charges register searches, how are they doing and how quickly are we getting them on? While I'm waiting for that, something else that I've been interested in, do you all send the buyer client and the seller client a copy of the agent's particulars? Obviously, we're going to get a memorandum of sale for the estate agent. Obviously, we're going to get a set of particulars, but do you send your client a copy of them? The reason I mention that is I dealt with a matter a few years ago where the client had a paper copy of the agent's particulars and the particulars had been prepared when the property first went to market. The property had been on the market for nearly 2 years, and in that intervening period, the estate agent particulars have been refreshed and altered. So the lawyer on sale gets the altered particulars, and the client seller has the original particulars, which are different. And again, there was an issue there on the basis that the contract had been drafted on the basis of the new particulars, not the old ones, and the client thought the property was being sold on the basis of what the estate agent had been instructed in the first place. Always check and make sure your client sees a copy of the agent's particulars that are being provided to you. Other things that I'm concerned about, client verification when we're onboarding clients. How many people are using electronic verification systems to verify client ID? How many people are undertaking a risk assessment with regard to clients when we're onboarding clients? So we're undertaking a risk assessment with regard to the transaction, a risk assessment with regard to third parties involved in the transaction, risk assessment relating to client. Should be doing that. Remember, there's no such thing as a collective client either. It's important that if we're acting on behalf of more than one entity, that we verify their ID. So if we're acting for Mr. and Mrs. Smith, we've got to verify both their identities, and we've got to deal with them as individuals. As long as they have a common purpose with regard to the transaction, we can act. But it's important that we understand and appreciate that these are individuals that might require different levels of guidance. They may have different attitudes to risk, etc., and we've got to deal with that. Okay, some of the things that I'd like to talk about, if I could, are issues concerning signing documentation and executing deeds, etc. Again, important that we understand and appreciate that it isn't enough simply giving a client a document to contract, for example, mortgage deed, for example, to sign. It's important that there is an explanation relating to that documentation so the client understands the commitment that is being entered into, and also the importance and significance of that document in the conveyancing process. So, for example, if our client is signing a lease, it's important that the client understands what that lease is and what the client is committing to. The client will be committing to the covenants and obligations that the lease contains, and will also be committing to, for example, service charge, a contractual obligation to pay an unascertained or unascertainable future expense. Does the client understand that? On service charge, does your client know that where estimated service charge accounts are produced, or 3 years service charge accounts being produced on the assignment of a lease, that those service charge accounts cannot be relied upon as a true and fair indicator of what service charge could be going forward? again, some points really that I want to sort of develop, if I can, with regard to this. If you are providing the client with a copy of a lease and a copy of service charge accounts or management regulations, do you explain to the client what these documents are? And do you also explain to the client, for example, with regard to service charge accounts, that it's impossible for us to give advice to the client about whether the service charge accounts are accurate, whether or not they are a fair indication of expenses that the landlord is incurring or has incurred as per the lease? So I think, again, we've got to limit our retainers so that we're not generating liability. One of the key things with regard to the Building Safety Act is to say to clients, look, the Building Safety Act could well apply to this building in which your flat or apartment is situated. The implications of the Building Safety Act are that it is likely that the landlord or accountable person is going to increase costs in connection with building safety management, and the lease will enable the landlord, the accountable person, to transmit those costs into service charge, which you're going to be liable for. So important that we sort of set the scene relating to clients. Anyone got any views on that? I mean, again, I appreciate that, you know, as far as high-rise flats and apartments are concerned, it's a sort of an urban context rather than a rural context. But it's important, if you are buying and selling flats on behalf of clients, that you understand and appreciate that the Building Safety Act applies. Next thing I want to talk about, not on the slide, but again, important, again, with regard to residential leases. Do you advise clients about the potential problems associated with Airbnb letting, keeping of pets in flats and apartments, and the fact that most leases are going to preclude or prevent it? And the other thing that I think is interesting with regard to restrictive covenants, do you advise clients about the existence of restrictive covenants in connection with property that's being acquired, but then highlight to clients the fact that it may be difficult, if not impossible, to determine whether or not a covenant is in fact enforceable or otherwise? So again, I think that's so important. All of this really is just scoping the retainer to make sure that clients understand what's being done and what's not being done, so clients appreciate the limitations associated with your role. Again, I'm just looking to see if there's anything else in the chat box, and I don't think there is. Just bear with me. Yeah, nothing as yet. So I'm interested in comments and anything else that's worthy of discussion. I've got some other things that I'd like to talk about, if possible. If we're undertaking searches on behalf of our clients, do we explain to clients the limitations of those searches? And do our clients understand the position relating to the searches that we do? So again, statutory charges registers, etc. Is it in your system that you report to the client issues associated with planning, sewage, roads, etc., and consider your client's objective in connection with search results? Your job is to assess the result, but this is an important point. Your job is to highlight risk, not assess or determine risk in anything other than issues associated with title. Issues with title, there is an obligation on you to assess or determine the risk, where, like John was mentioning, there was some form of imperfection relating to title. But with regard to searches, with regard to planning, with regard to sewage, with regard to anything, all your task is to highlight there is an issue, and then tell the client either that the client can undertake investigative work with regard to that issue to assess or determine risk, or that you could be instructed to do that on the client's behalf. With regard to the latter, it's important that A, you tell the client again what you're going to do, expanding the retainer, and where necessary, make sure the client is aware that there'll be a cost implication with regard to the work that you're doing. So again, you're perfectly entitled to charge clients for additional work that you do, subject to this caveat: you are required always to provide a base level of service. So even no matter what you say in the retainer, there's always an expectation that you would do that which a reasonably competent conveyancer solicitor would do. There's also an issue that you would always report to a client anything that is materially adverse to the client's interests in connection with the purchase. So you've got to be aware of those two things, but you can, as far as the retainer is concerned, limit the scope relating to searches so that you're just highlighting to the client the search results, highlighting to the client the existence of risk, and then suggesting to the client that either they or you undertake further inquiries relating to that risk. I'm just looking at some of the notes that I've made over the last few weeks that I want to talk about. Be careful with ground rent in leases and ground rent review provisions. Make sure that if the lease contains ground rent review provision, you warn the client of it. Where the ground rent review enables you to ascertain what the review will be, then that's fine. Where it's impossible to ascertain what the ground rent will be at review, warn the client. So I've dealt with things over the years where the ground rent has been reviewed and the mechanism or formula for review has been a percentage of market value of the property. Well, in those circumstances, how can I, in 2023, determine what the market value of the flat or the apartment will be in 2033? And if the ground rent is increased to 4% of market value of that flat or the apartment, what will market value be and what will that mean in connection with an increase in rent? Next thing to talk about is valuation and survey. Don't know if you've seen, don't know if I've mentioned to you, but the RICS website has a consumer guide to survey and valuation. Quite useful. You should always be advising clients of the need to obtain the best possible survey they can afford, particularly where they're buying flats and apartments to which the Building Safety Act relates. The quality of survey is so important to determine whether or not remediation work has been undertaken or is required to be undertaken in connection with building safety measures. As far as a survey or valuation is concerned, it is important to appreciate that your task is to read the survey or valuation that the client obtains. A few years ago, I did some work for a firm, and they, in their report on title, said that they wouldn't look at any survey or valuation that the client had obtained. You can't do that. You've got to look at it. You can scope the retainer so the client is aware that all you're looking at are issues relating to title. But you do have to look at the survey or valuation. You can't sort of exclude it from your list of tasks that you are to perform. I'm going to ask you a couple of more questions if I can to see what people have to say. Again, important with regard to risk assessment. Would you undertake a risk assessment of a file or review the file before you exchange? And would you undertake the same sort of assessment before you complete? Two schools of thought. School of thought number one is you risk assess when you're onboarding the client, when you're starting the transaction. Risk assessment undertaken or review undertaken when you're producing the report on title pre-exchange. And no need to do a further risk assessment at completion. My view is, second school of thought, that you should be constantly aware of the need to reassess risk as the transaction progresses. That risk assessment isn't a simple one-hit exercise when we're onboarding the client. It is important to keep it under review. There may be things that are happening, there may be issues that are outstanding that highlight or generate greater risk, in which case it's important that you identify that and it's identified to the client, and also that you undertake measures and steps to try and limit risk as and when those issues arise. Two or three things, other things that I want to talk about if I can. Again, I'm just waiting for people to contribute in connection with the issue in the chat box there. But one or two other things I want to talk about. Again, in dealing with completion, would anyone insist that their client inspects the property before completion, just to check that the seller is geared up to vacate, say on the evening before completion, or to check the state and condition of the property before completion takes place? And would anyone want the client to inspect the property at exchange of contract? My view is if a property is empty or derelict, or a property is prone to vandalism, then I'd probably want my buyer client to inspect, if possible, at exchange, or for someone to inspect at their behalf. And I probably would also want an inspection to take place as well, just before completion. Remember, if your client is inspecting the property pre-exchange, your client is bound by anything that they actually see and bound by anything that a reasonable inspection would reveal, the concept of constructive notice. Do you tell clients about that? Again, a lot of firms will tell a client to inspect, obviously, but they won't tell the client why they want an inspection, what they're looking out for, state and condition of the property. Information in the inquiries before contract. Is it accurate, you having seen what you've seen? Physical extent of the property and the existence of third-party interests. All of these things need to be drawn to your client's attention so that when they are inspecting the property, they understand what you're wanting them to do. And importantly, when the clients have inspected, if there is anything of concern or anything that they've identified, then it's imperative that they report to you what they see and you incorporate that into your report on title. So it might be that the client inspects and, I don't know, there's evidence that the neighbour's parking cars on the driveway or utilising the garage of the property that the client's buying. There might be some form of evidence of an informal tenancy that could potentially be binding on your client. You could have a situation where a proprietary estoppel arises. So you could have someone in occupation in the residential property on the basis that assurances or promises have been made to them by the owner of the property, to which they've acted to their detriment, in which case that estoppel would create an equitable interest that would be binding on a buyer, binding on your client, even though it's not recorded on the title. Your client needs to understand and appreciate that. Other things that I think are important and other things that are worthy of explanation, and we'll perhaps have a look at these at a later date, are issues with regard to insolvency and setting aside undervalued transactions and this sort of thing. Again, I'm dealing with a couple of cases relating to that at the moment, which is interesting. Now, I know that we're going to undertake a bankruptcy and enforcement of judgment officers search as part of the conveyancing process. But what happens, or what do we need to be aware of, where we are buying and in previous ownership there's been an undervalued transaction? Is it possible that undervalued transaction can be set aside, meaning that our client doesn't acquire a good title? We'll have a look at that. The law is quite complicated, but it's quite important that we understand and appreciate the implications of undervalued transactions or transactions that are designed to defeat creditors and the possibility of such transactions being set aside. Other things that I would like to talk about today, if we could, last thing really that I think is of interest to me, and again it may be of interest to you, is issues with regard to planning conditions. And what happens if there are planning conditions? Well, do planning conditions run with the land? They can do. Are they binding on a buyer? They can be. If we've got outstanding planning conditions, what do we do? Well, first of all, if nothing else, we report to our client their existence. Is it possible for planning conditions to be fulfilled by the seller? Answer yes. What is the position with regard to breaches of planning permission, etc., or where planning permission hasn't been obtained in connection with an activity or development? On the issue of planning, point number one, for acting for a buyer, what's our client's objective? 2, our task as a conveyancer is to assess or determine the client's objective and to check that there is planning permission or some form of lawful use that means our client can achieve the goal, achieve the objective. Where our client wants to undertake development work or wants to alter the property, etc., then again, we need to be careful about scoping the retainer. Am I going to be giving the client advice on construction issues or planning issues, or am I, as a transactional property lawyer, simply obliged to tell the client about the current planning status of the building or property that's being acquired? Again, I'm quite happy to give clients construction advice, planning advice, as long as I am limiting my retainer, as long as the client and I understand what my role is in connection with development. But as a transactional property lawyer, I repeat, my task is simply to advise the client as to the current planning status of the building or property that's being acquired, and to check that that status is consistent with my client's intended use. A number of things really that flow from that, which we can talk about on sort of future occasions. But again, I repeat, and I go back to basics. As a transactional property lawyer, my job is to highlight risk with regard to planning issues. It isn't to assess or determine risk of enforcement action or likelihood of success or otherwise in connection with defending enforcement proceedings or applying for planning permission. One or two other things before we finish today. I would love people to let me know about what else you'd like to know about, what burning issues you have. What I'm going to do, I think, is see if we can get some case management systems to come along and to have a chat about different products. I think that would be useful. I'm going to get a search company to come along and talk to you about some issues relating to searches. And I'm going to try and get a professional indemnity insurer to come along and talk to you about claims and claims avoidance, about best practice and how that sits relating to claims. I think that would be a useful exercise. But I'm more than happy to talk about or get people to talk about any issues whatsoever that you think would be relevant. Again, as before we finish today, 2 or 3 points really, if I can, unless someone's got anything else that they want to talk about. One, massive thank you to John and Liz and Robert Kelly from Stewart Title. Robert, John, any other issues about your policies? Am I right in thinking that in Northern Ireland there are standard policies and I can just go online and obtain a policy using that system?
That's correct. They're not as extensive as they would be in England and Wales. Like Scotland, they're not as extensive as England and Wales, but there's policies that you can go online, provided that the assumptions, you can accept the assumptions. You would then get a policy and a premium, and there would be no real contact with any of us as underwriters. You can do all that online without any further interaction between us.
Yeah, thank you. And John, what would happen if it was something unusual, say a commercial development site, and there isn't sort of a standard policy? Do they talk to you, or how would that work?
If you tried to do that, it would then come offline and it would be referred to probably me. So if you go in and you can't accept the assumptions, even if you complete the application saying you can't complete the assumptions, it'll then come offline and it'll be sent to one of the underwriters, who will then contact you directly to discuss it further. The online system, the premiums are based on that the assumptions are correct and that the insured use, etc., is what you're looking for. So if you go in and the online system says you can only use it as residential or as a dwelling house, and you're going to build 5 flats, it then comes offline and the premium would probably be higher as well.
Yeah,
so bear that in mind.
Yeah, and I think the other thing, John, is it's not right to think that, to talk to you, it's got to be something that's sort of similar to an online policy. You can have a look, you and the underwriters can have a look at all sorts of risks and explore whether or not you can insure them. Is that fair comment?
Well, you can sort of hybridize the policies, if you like. Right. So if somebody's looking for something that we don't do, and we might do it in another jurisdiction, we could look at doing that. For example, in Scotland, we don't get really any applications for build-over type agreements, but in Northern Ireland, build-over agreements appear to be an issue. If somebody from Scotland said, we've got a build-over issue, we'd probably look at the Northern Ireland policy and try and make it fit Scotland, and vice versa. If we had something in another jurisdiction that somebody in Northern Ireland asked for, we would see if we could make it fit that particular jurisdiction.
Because build-over agreements are a real problem, aren't they, in Northern Ireland? I noticed that. So again, let's talk about that next time. I think that would be quite useful. And John, if we do that, can you sort of share with us your knowledge about how an insurance policy would work?
There's not a lot of underwriting in it. So we could do that for you.
All right, we'll do that then. Okay, lovely. Well, everyone, thank you so much for coming along today. Robert, John, Stephen Smith from and Liz from Stewart Title, thank you. Everyone that's attended, thank you so much. Next occasion, give me lists of topics to talk about and we'll talk about them. But meantime, thank you for your time. I appreciate it. Thank you, everyone, for coming along. Thank you for Stewart Title for sponsoring this event. And we'll look forward to seeing you on the next occasion. Thanks, everyone. Stay safe and speak soon. Thank you. Bye-bye.
Bye.
Thanks, John. Bye-bye.
Bye. Bye.